Hello all, and welcome to 3PB's Employment and Discrimination Group's case law update on the 14th of September 2020. Now, you may be watching this in the evening or in the morning, but sit back and relax because Stephen, my colleague, who is learned and also technologically astute, I'm joined by today, and he is a specialist employment and discrimination law barrister and also sits as a fee-paid judge. My name is Simon Tibbitts, and I'm a specialist employment and discrimination law barrister at 3PB. Now, detailed articles to support this webinar were published in our monthly newsletter, which was published last Tuesday, the 8th of September, edited by Sarah Clark, and is available for you to read at your leisure. So without further ado, I'm going to pass over to Stephen. I think you wanted to mention C and D. Is that right?
Yeah, I did, Simon. But first of all, what I want to be clear about is that when you say I'm technologically astute, I'm no more technologically astute than most people have become because of the pandemic. But there we are. Very nice of you to flatter me in that way, just at the outset. Yeah, this is a good case. I mean, I think it's one that really should be read by practitioners, certainly the relevant parts, because it's becoming a common problem in tribunals that pleadings are just too long. They are just both the claim forms and response forms. And I'm not in any way surprised by what Her Honour Judge Tucker said in this case in C and D, because it's been, what I'm surprised about is the fact the EAT hasn't said it sooner, because it's just more and more now. These pleadings are becoming, it's like reading short articles in a magazine. I mean, they're just too long. I refer parties, Simon, and solicitors to the practice direction, the practice statement of the Employment Appeal Tribunal that was issued by the then President, Mr. Justice Langstaff, the first paragraph. Too many notices of appeal are simply too long. If a notice of appeal is too long, focus on what really matters can easily be lost. Justice then suffers. A change of culture is needed. Now that, of course, is in relation to the EAT and appeals at the EAT. But what Her Honour Judge Tucker was saying in this case was that really, she didn't put it quite in these terms, but in reality, what's being said there is much about what she's saying in relation to pleadings in the ET in the first instance. They're just too long. You will lose and possibly even confuse tribunals if you put too much into the ET1. You can't see the wood for the trees. It's as simple as that.
So, Stephen, why is there a tendency to plead cases in this way, do you think?
Well, I think there is a fear by, and in fact, this is something that Her Honour Judge Tucker picked up on, and she made this remark in her judgment. There's a fear by practitioners that if they don't write their pleadings in a narrative way, and if they leave out just the slightest detail, then something could be left out in terms of an important fact, or more commonly, I think what people are concerned about is there is a tendency by representatives in tribunals to try and use and capitalise on anything that's missing from an ET1 in cross-examination. Or indeed an ET3, and it's quite common. You often hear representatives say, "Well, that wasn't in your claim form, or that wasn't in your response to the claim." And I think the simple answer to that is, obviously in submissions, is that of course it's not in the claim form or in the response form, because it didn't need to be in the claim form or the response form. That's the sort of thing you'd expect to see in a witness statement. So I think that fear is effectively overtaken practitioners, and they now need to just relax a little bit and think about what is really important in the claim form or the response form. I think also there's another reason why it's happened, and dare I say it, I don't think it was Churchill who said it. I never know who said it. Somebody said, "I'm sorry this letter's so long, I didn't have time to make it shorter." And I think this is one of the problems that practitioners are facing, and of course we're all working under time pressure, and so often it's easier, simpler, and frankly it might even be out of laziness, just writing something out in narrative form. You don't have to think about it. And often the other thing I see is particularly claim forms where you can tell that it's been written by the actual lay client. They've written it themselves, and all the solicitor has done, if they're legally represented or any legal rep, is simply top and tail it or switch it into the third person. And now that's not acceptable either. That's where I think the problem is coming from.
So, Stephen, what direction did the EAT give in relation to pleading cases in this case then?
Well, I think the EAT gave a very helpful summary of what, frankly, most people should have picked up on when they're reading if they go back to their law school book. In reality, that's effectively what the EAT was saying. The claim form should state and set out a very brief statement of relevant facts. That's what you would expect. The cause of action relied on by the claimant, and it should distill the relevant factual matters to their essential or key component parts. Now that's what the EAT said. That's the guidance the EAT gave. And the EAT went on to say, in that way, a respondent should then only need to simply respond by agreement, not agreeing, and denying. I mean, those terms, of course, we're very familiar with. So that's really the direction that was given by the EAT. It seems to me that that actually is just setting out the bare bones of how anyone should approach a pleading of a case. I should say, actually, but I didn't, in this particular case, the ET1 particulars ran to 37 paragraphs and over 6 pages, and that astonished Her Honour Judge Tucker. Well, what astonished me about that is it was only 37 paragraphs and 6 pages. I've seen ET1s that run to much longer than that. So the fact that Her Honour Judge Tucker was raising this about an ET1 of that length, I'm not saying that's in itself is short enough, but the fact is that's actually comparatively short in comparison to some of the ones that I have seen. So when approaching it, this was the guidance she set out. She set out a brief statement of relevant facts, cause of action, and distill those relevant factual matters into their essential or key component parts. That was the advice of the EAT.
So, Stephen, what suggestions would you give to those who are drafting claims or responses?
Well, I think one of the best things you can do as a representative is have the statute in front of you. The one luxury we have as employment lawyers is that pretty much all of our law is statute based. And if you've got the Butterworth's handbook, I don't know, this isn't product placement, I trust, but maybe it is. Hopefully not. But if you've got a Butterworth's handbook, then have it in front of you when you're drafting the pleadings, because that's a very useful checklist as to what you need to include in there. It's surprising how many people, when they plead a case, for example, victimisation, they don't even mention what the protected act is. They just say, they're quick to say what the detriment is, but they don't say what the protected act is. All of this, I mean, a classic example is whistleblowing, where you've got to go through each of the ingredients. Set out the factual position in relation to each of those matters. If you have the statute in front of you, it's a really useful reminder to an aid memoir to what you've got to put in your pleadings. Same when you're providing a response, because if you've got the statute in front of you, you will spot where the claimant has failed to address the particular aspects of the cause of action that they rely on. And one of the advantages of that is that if you then have got the statute in front of you and you can see where the claim is missing the information you need, you don't then have to say, this case is not properly pleaded, we require the claimant to properly plead their case, and when they've done so, we reserve the right to amend our response form. That again is an invitation for trouble, because all you're going to do is invite a claimant to possibly expand on their claim. And then there's this whole issue of, well, was it in the claim form originally, or is it something that's been added subsequently? Does this require an amendment? Doesn't it require an amendment? The best thing a respondent can do in those circumstances is try to identify as best they can, without actually, it's not for the respondent to assist the claimant, obviously, it makes absolute sense. But the respondent should try and identify what the case is about. It is the respondent's duty to try and assist the tribunal. And if the respondent can identify what they believe the case to be about, what the causes of action are themselves, then they've already confined the case to what they understand it to be, and they've also identified what they needed by way of further information. And at that point, they can just simply ask the claimant, this is what we need from you to understand your case. And that will limit the case, it will contain the case. That's what's really important, not just for the respondent, but also for the claimant and the tribunal. It assists everybody in the long term. I should add, Simon, that one of the criticisms of the EAT, and the reason why the EAT was concerned about the lengthy pleadings, is because it does result in valuable time being lost, it does result in costs being increased, and it does result in delay. Those are the three things that the EAT pointed out in the judgment. It's inevitable because, as I say, you end up with these arguments. You turn up to a case management hearing trying to ascertain what the issues are, and if the claim hasn't actually been properly pleaded and the response hasn't been properly addressed those points, then inevitably it's going to be impossible to actually identify what the case is about, and that usually does lead to a delay. Simon, I think we're going to hear from you now. I've said enough for the time being. You're going to talk to us about this recent case, aren't you, involving Kelly and PGA Tour. I vaguely recall this case was before the AT a couple of years ago. Why is it back in? What do you think is relevant about it? Why do you want to talk about it now?
Yes, so this case had a bit of a protracted history in the Employment Tribunal and the EAT. The most recent judgment is quite lengthy, and I've produced a more detailed written summary that is on our website and in the recent newsletter. But the background facts are in short as follows. The claimant, Mr. Kelly, was the PGA Tour Group Marketing Director. And basically, he'd been employed by the PGA Tour in a marketing function for about, well, over 2 decades, about 26 years. A new CEO, a Mr. Pelly, sounds quite a lot like Mr. Kelly, so be careful, was appointed, who had a new vision or strategy for the tour. And within a few months, basically, of the new CEO joining, the claimant had been dismissed at age 60. Now, the claimant's primary case before the EAT back in 2016 was that his dismissal was unfair and an act of direct age discrimination. The respondent conceded the dismissal was unfair because no procedure had been followed, but the claimant's age discrimination claim was dismissed by the Employment Tribunal. The claimant appealed to the EAT, and the EAT back in February 2018, what you're probably vaguely recalling, Stephen, dismissed that appeal. Now, I've referred to this case now because of the tribunals and the recent EAT judgment on the reinstatement and re-engagement issue pertaining to the successful unfair dismissal claim.
So, effectively, as I understand it, there was an issue about reinstatement and re-engagement as a case. Is that right?
Yes. So the ET refused to reinstate, but they did order re-engagement, i.e. in an alternative role. And that alternative role was Commercial Director, China PGA European Tour, to be specific. The respondent had objected to re-engagement essentially on 2 headline grounds. Namely, 1, the respondent had lost trust and confidence in Mr. Kelly, and therefore re-engagement wasn't practicable at all. And secondly, in any event, the specific China role had an essential requirement that the post holder speak Mandarin. Mr. Kelly did not speak Mandarin. So they said it wasn't practicable to re-engage him into this specific role.
It does seem a bit strange that a tribunal at first instance decides that they can re-engage or reinstate, I think it was a re-engagement rather than reinstatement, into a role that requires somebody to speak Mandarin when Mr. Kelly couldn't. So how did the tribunal find that was practicable in the circumstances?
Well, quite. The ET accepted as a fact that speaking Mandarin was an essential requirement, but essentially, without going into too much detail, a more cynical person might say, fudged it, drawing upon various different factors such as his proficiency at learning languages and his desire to learn the language, and the fact that he could, in theory, have an interpreter for a period of time. So they effectively went on to substitute their own view. The EAT stated clearly that the ET had erred in that regard, substituted their own view for that of the respondent on this point, and confirmed that which employers and those representing them may want to take note of. Where the employer has genuinely, for cogent reasons, distinguished between essential and preferable elements of the job description, and the employee does not meet an essential requirement, it will usually be an error to require the employer to re-engage the employee in that post. Thus, the tribunal, having accepted that an ability to speak Mandarin was genuinely an essential requirement of the job, the majority failed to give due weight to the respondent's commercial judgment in that matter when considering the issue of practicability.
More cynical than you and I, Simon. When you mentioned it just then, I thought, goodness me, I nearly fell off my chair. Anyway, that all seems quite logical to me, but what about this issue of loss of trust and confidence? What do they say about that?
So the respondent argued that it wasn't practicable to re-engage at all because it had lost trust and confidence in the claimant. The respondent argued that they lost trust and confidence essentially for two reasons. Firstly, the view the CEO had formed of Mr. Kelly's capability, and secondly, the respondent had discovered post-termination that Mr. Kelly had been covertly recording some meetings with the CEO. Now, it's important to note that the tribunal had accepted at the liability hearing, i.e. that determined the age discrimination claim, that CEO had dismissed the claimant not because of his age, but because he did not have confidence in Mr. Kelly to perform the role as he required it going forwards. And the tribunal went on to hold further that those views held by the CEO were genuine. However, in the remedy hearing, the tribunal went on to find and to state that, to quote, the tribunal has to reach its own conclusions as to trust and confidence. The majority view was that the issue of trust and confidence arising from doubts about the claimant's capability and integrity arising from the covert recordings are not so significant as to make it impractical for the claimant to be re-engaged. The concerns raised by the respondent about the claimant's ability are necessarily emphasised by the respondent and do not reflect reality. And in short, the question of trust could be overcome by all if reasonable professional behaviour is maintained.
I'm sorry to interrupt there, Simon, but that does sound a bit like the tribunal were substituting their view for that of the respondent, doesn't it? I mean, things like the tribunal has to reach its own conclusions as to trust and confidence. That sounds a bit like they're forming their own judgment on that. What are your thoughts on that?
Well, indeed, Stephen, your astute legal mind shows its prowess once again. That's exactly what the EAT held. The EAT cited United Lincolnshire Hospitals and Farron to affirm the guiding principle that a tribunal must consider whether an employer genuinely and rationally believes that trust and confidence had been broken so that re-employment would not be practicable, i.e. not being capable of carried into effect with success. Now, the claimant had sought to suggest that whether a view was rational meant the same thing as asking whether the employer's view was reasonable. The EAT, however, did not agree, stating that a belief may have a rational foundation in evidence or information and be genuinely held by an employer, and yet not be reasonably reached. Thus, ultimately, the question for the tribunal is whether it is practicable for this employer to re-employ this employee. The EAT thus held that the tribunal in this case had impermissibly substituted their view for that of the respondent on the issue of trust and confidence. And given the evidence was clear, i.e. the tribunal's own factual findings at the liability stage, that the CEO's view was both genuine and rational, not reasonable, the EAT substituted a finding that it was not practicable to re-engage the claimant at all.
Okay. So what's your view on this? What's the most interesting thing about this judgment then? Why did it catch your eye?
Well, as I say, there are a lot of things in this judgment, and I haven't covered them all, but it's on the loss of trust and confidence point because, and it's really actually in relation to arguments the claimant raised in defence of the respondent's appeal to the EAT. The most interesting of those arguments which the claimant advanced before the EAT was that this wasn't a conduct dismissal, and nor was any contributory conduct alleged or found. When one looks at the structure of Section 116 of the Employment Rights Act 1996, the claimant's representatives suggested that an employer could not in fact rely on a trust and confidence argument in relation to a capability or an issue relating to capability as opposed to conduct when it came to the question of whether re-engagement was practicable. In short, His Honour Judge Auerbach disagreed with that judgment, holding that there was no reason in principle why, and nor did Section 116 prohibit, employers advancing an argument that it was not practicable to re-employ on the grounds of a loss of trust and confidence in cases where the reason for dismissal was other than conduct and where no argument of contributory fault had been raised. So where does that take us? Why am I referring to this? Because I think the really interesting or key point to draw from this case is what I consider are the terms of what you might call the implied guidance that the EAT gives as regards cases where loss of trust and confidence are advanced to refute practicability of re-employment. And I'll just quote this part. The EAT stated that an employer must identify the particular conduct or other factual state of affairs on which they rely. And the tribunal must then consider on the evidence whether the individuals concerned genuinely and rationally believed both that this conduct had occurred or other factual state of affairs existed, and that it meant that trust and confidence had broken down so as to point to the conclusion that re-employment would not be capable of being carried into effect with success. Now, I've deliberately emphasised a few points in that quotation, but Stephen, I don't know about you, but I consider that that statement by His Honour Judge Auerbach could encompass a whole range of circumstances and factual matters. And when you read that in conjunction with the fact that it is, of course, the employer's view that needs to be rational and genuine, noting that reasonableness has no place in determining the issue of re-employment, it seems to me that this case ultimately has widened and lowered the threshold for the employer in defending against an order for re-employment. In essence, an employer could point to a whole raft of different circumstances because the concept of implied trust, or not implied, but the loss of trust and confidence is somewhat of a nebulous and broad concept in itself. So if an employer can point to any factual state of affairs and only needs to show a genuine and rational view, that is its view, and only needs to show that that points to a loss of trust and confidence, it seems to me that the potential grounds on which an employer can refute and say that it's not practicable because of a loss of trust and confidence are very broad indeed.
Well, lowering the bar in what is, in fact, of course, we remind ourselves, it's the primary remedy in tribunals, in statement of re-engagement, but lowering the bar in what we all know in reality are orders that are very rarely made. The last figures I saw, I think it was something like 0.5% of unfair dismissal cases that are issued result in a re-engagement or reinstatement order. Lowering the bar even further, I can see that it's going to, I suspect we'll have a lot of respondents just arguing all sorts of points about trust and confidence. Presumably that's your point, isn't it? That's really what you're getting at, isn't it?
Yes, well, indeed. And you point out that it's a rare thing. I mean, I think when we were speaking previously, I have to confess, I've only come across an actual argument about reinstatement or re-engagement only a handful of times in my career. And it's something which I think those representing the employers often sort of ignore. And it's an important point to note because, as we both know, there are some quite significant consequences in terms of costs and penalties if an employer doesn't address their mind to this. But what this case shows is that if you do take note of this case, and incidentally, this case is quite good for setting out the background law on this point. But if you do take note of it from an early stage and address your mind to it and get your client, your employer client, to address their mind to it, you probably can avoid a reinstatement or re-engagement order without much effort.
Well, it's interesting you point out that because, I mean, the reality is that it does seem to not crop up very often at all. And like you say, I mean, I've only dealt with a handful of cases where reinstatement or re-engagement has been an issue. Of course, I suppose when you think about it, the acrimony that often exists in a dismissal, it's not surprising that the claimant doesn't really want to go back. But sometimes, and it might well be, certainly with the what's on the cards and the economic the clouds that are looming, it may well be that claimants are seeing this as a point they really want to start fighting, because a job might be worth more than the acrimony that has to be endured if you go through it and go back. So it'll be interesting to see what happens with it, whether that actually does become much more of a focus in tribunals than it perhaps has been up until now.
So, Stephen, I think you were going to talk about Papa John's Pizza and Reed. That's the next case. So,
yeah,
what was this case all about?
Well, I think this is another really good one for practitioners because it raises three interesting points. Again, people might read it, they might not. It's a relatively short judgment, actually. I think it's only about 11 pages, which is, I think, is mercifully short for an EAT decision, and that's great. But of course, it involves three things. First of all, there was an interesting point about lack of evidence. The second point is that often this is a problem for claimants. Who is the employer? Is somebody an employer or aren't they an employer? And the third point, which is quite an interesting point, was a conflict of interest point that arose in relation to the claimant's solicitor. So there are three things in there for us to get our teeth into.
So why were there two respondents in this case, Stephen?
Well, as you can see from the case title, there were two respondents. They were two separate limited companies, and they were both working as franchisees of Papa John's Pizza. So if you live in Norwich, you'll be quite familiar with this. There are two Papa John's Pizzas in Norwich. Apparently, you don't just get the choice of one. You've got the luxury of choosing which of the Papa John's pizzas you're going to go to. God, this is tremendous product placement. Butterworth's and now Papa John's Pizzas. But you've got two choices in Norwich, apparently. But they're both run, you may not know, by two separate limited companies, entirely separate from each other. But there must be some sort of link and connection because, as Reed in this case was sent to work for one of the Papa John's Pizzas by the other. Not quite sure why. I think they might have been sister companies or something along those lines. They might have been short. But anyway, in a nutshell, what the case was about, the claimant brought a claim for pregnancy discrimination. That she said she was dismissed because she was pregnant. And she also brought a claim for holiday pay. And there was an award made to her by the Norwich Employment Tribunal of £478.36, don't forget the pence, for a finding in relation to the national minimum wage. There was clearly some issue there about the national minimum wage as well. But the bit that we're really interested in, and what the EAT had to get involved in, was the discrimination point and the dismissal by way of discrimination. The claimant brought the claim against the two respondents because, as I say, she'd worked not just at one site, but she'd also worked at the other Papa John's site. And even though they were operating, as I say, independently, they're independently owned and managed at different sites, albeit, and they were separate franchisees. She was successful, as I say, in her claim for discrimination. And this is the first point that comes up in this case, which I'll deal with this quite quickly. And it just, again, it's particularly practitioners who are watching this, it's a timely reminder of going back to your clients at this moment in time. Great time, great marketing opportunity. Go back and just check they've got their documentation in place, because the EAT actually said, they used this lovely term, excoriating. The EAT was excoriating about a lack of documentation in company records, which the EAT suggested. In fact, the EAT went further and suggested that what they did see and what did exist, they thought was possibly fabricated. And so it is really a timely reminder for employers to get their house in order, particularly with national minimum wage cases, because of course there's a presumption against the employer. The employer has to have the records to show that they've complied with the national minimum wage. So if you haven't got records of when your employees are working, then you can get yourself into all sorts of difficulties as to whether or not you've paid them the national minimum wage. But in any event, there was a lack of documentation just generally, and it damaged tremendously the respondent's credibility in this case. So that's the first point.
Okay, Stephen. So what did the EAT say about the tribunal's decision that both respondents should be liable?
Well, this was the next point. The EAT held that the two respondents should be jointly and severally liable for the claims generally, and it wasn't at all clear from the judgment why that was the case. Why the EAT at first instance had decided that the two respondents should be jointly and severally liable. Of course, we know that in discrimination cases, often where you've got a individually named respondents as well as the company being named, then in those cases, if those cases are successful, there will often be a joint and several liability, and there's authority in case law on that, which I don't need to touch upon for the purposes of this review. But the real issue, I think, was that it wasn't clear to the EAT, and in fact, when this went through the SIFT, His Honour Judge Richardson, using his own initiative, I think. I don't think it was Burns and Bark procedure, but he requested further information from Employment Judge Postle, who was the first instance judge on this case, to clarify why it was the case that the two respondents should be liable. And the answer to that from Employment Judge Postle was that the claimant had been sent to work at the second respondent's shop, to work, which was run as a separate company by the second respondent, but the tribunal just simply couldn't say precisely when this was because of the respondent's lack of records. So the tribunal took the view that it wasn't the tribunal's role to decide and try and unpick all of this. They took the view that there was quite clearly an acceptance that she did go and work at the second site, and therefore they should be liable in this case. The EAT found, however, that was an error of law, and the first respondent, always maintained that the claimant had worked for the first respondent. So in this case, that was the name of the first respondent in this matter was Aftala Norfolk Limited. I think I pronounced that correctly. So Aftala, and there's Whitestone Norwich Limited. Those were the two companies. Now Aftala always maintained that they employed the claimant, and Whitestone never did. And the dismissal letter was written by Mr. Anton, who was, I think, a director of the of Aftala. Was certainly he was only ever connected to Aftala. And it was sent by another one of Aftala's employees, Mr. Shaw. Yes, Mr. Anton was a director of Aftala. So the letter of dismissal was sent by him. Thus, there was only ever one answer, the EAT said, to who was responsible for the claimant's dismissal, and that was Aftala Norfolk Limited. It had nothing to do with Whitestone. And so even though the claimant may well have gone and worked at Whitestone, the reality is that Aftala said that they employed the claimant, and Aftala were the ones that dismissed the claimant. And in those circumstances, it wasn't appropriate for the second respondent to be liable for any damages, even though the ET considered that they were in some way part of the employment relationship.
So, Stephen, wasn't there a conflict point, and what was that all about? How did that arise?
Yeah, there was. Now, this is where the case, I think, also takes a turn, which is quite interesting. So, EAT said, it doesn't matter that the claimant was seconded to the second respondent from time to time. First respondents, the one that's in the firing line here, they're the one that employed her. They're the one that dismissed her. Now, interestingly, Mr. Anton, who I've just mentioned, who's the director of the first respondent, he actually, when he got the 81, went to get some advice from a solicitor. Of course, takes up what solicitors commonly do. And again, this is something that I think is real interest, should be of real interest to particularly those watching as solicitors. Went to get some advice. It's not uncommon. I was a solicitor for 10 years, and our firm used to do free half hours or fixed fee interview for half an hour. And it appears that Mr. Anton went and took up this opportunity with a firm of solicitors. Interestingly, it was the same firm of solicitors who ended up acting for the claimant. So Mr. Dean, Graham Dean, I think is the name of the firm. And so there was then this issue of whether or not there was a conflict of interest, because Mr. Dean, who was representing the claimant at this point, also apparently gave a free interview, a pro bono interview, with Mr. Anton about this very case.
So Stephen, more importantly, let's see if we can conflict you. Are you a Papa John's, a Domino's, or a Pizza Hut man?
Well, my preference, it's got to be Pizza Express, hasn't it? So having gone and seen Mr. Dean, as I say, interestingly, the respondent then decided they weren't going to have Mr. Dean represented. They went elsewhere. That was their choice, of course. They ended up being represented by Peninsula, in actual fact. And by all accounts, the representative of Peninsula only discovered that Mr. Dean, that there'd been this interview with Mr. Dean the night before the hearing. And on the morning of the hearing, raised it with Mr. Dean and then raised it with the tribunal and said, look, there's a conflict here. Mr. Dean really shouldn't be acting for the claimant. We think there should be this case. I don't know whether there was an application to dismiss the claim, but certainly there was an application for an adjournment or postponement, so that because of this conflict. So key point here: the respondent didn't raise this until the morning of the hearing. The EAT accepted the employment judge's position on this, and they did support the employment judge at this point. They said that the employment tribunal and the employment judge was right to proceed and carry on with the hearing, despite the alleged conflict. And that's not entirely surprising. I think that's actually a very supportive position to take, and rightly so, because we all know the delays that are going on in tribunals at the moment and the problems with getting things listed, and judicial resources so valuable that you don't want things being postponed or adjourned if it can be avoided. And obviously the employment tribunal judge thought, we need to get on with this case. The respondent didn't raise it until the morning of the hearing. That was obviously a very important issue for the first instance judge. And if the claimant's representative was taking advantage of confidential information, the EAT did so. Of course, there are cases where you could obtain an injunction preventing a party from relying on that. There's a High Court decision on that. But actually, when the EAT did a brief outline of what the case law was on this, they made reference to a Court of Appeal case of there's an Essex County Council decision, Boyce and Essex County Council. It's a Bayche, B-A-Y-C-H-E, and Essex County Council. That interestingly, that case suggests that an employment tribunal can't prevent a claimant having his or her representative represent them, even when the representative has somehow benefited from confidential information from the other party. Now, I haven't looked at that case. I don't know what that case says. I'm going to hold my hands up here in a minute. I don't know exactly what that says, but the EAT, I don't think, were particularly exercised by that, because it noted that, of course, it would affect justice if a solicitor or any representative who had been provided with privileged information or confidential instructions which were not disclosed and made use of, which were not disclosable, I beg your pardon, and were made use of. Obviously, such material would give, if there was such material and it gave an advantage in litigation, that's going to be against the interests of justice. But in this particular case, the EAT was satisfied that Mr. Dean had made clear that he had no recollection of the brief pro bono meeting that took place between him and Mr. Anton to the judge, and he wasn't subsequently instructed by Mr. Anton or the first respondent, and the respondent was unable to point to any matter it's said to be confidential, or going, or effectively giving the claimant an unfair advantage. So in those circumstances, the tribunal, the Employment Appeal Tribunal, didn't really have to get into too much of the detail on this. And the other point the EAT made, of course, was that it was unfair to effectively throw this on Mr. Dean and the claimant at the last minute, the 11th hour in the morning of a hearing, when Mr. Anton had known that he had met with Mr. Dean for many, many months before the hearing. So I think that, again, there's a salutary lesson there for practitioners. Interestingly, apparently, I only know this by reference to what was said in the EAT decision, the SRA didn't seem to think there was an issue here. I can't comment on the particular facts of this matter, but certainly as a practicing solicitor myself before I came to the bar, I would have been very nervous about having any involvement in this case, even if I'd done a free advice session with one of anyone connected with the other side. And it goes to show the importance of having your conflict checks in place, because this could have gone very differently. But the other interesting point here is that it seems that tribunals really aren't going to get themselves into, or certainly involve themselves in regulating conflicts like this. And as far as they're concerned, those are matters for the regulatory bodies, both the Bar Council, Solicitors Regulation Authority, etc. Those are the issues, and those are the bodies that need to involve themselves in that matter. Now, Simon, you're going to, I think, deal with the very last case that is on the list of those that you and I have picked as interesting. What's the name of this case that you're dealing with, and what's the relevance of it?
So this is a case of Gallagher and Abiello, if that's pronounced correctly. I should firstly say Dan Brown prepared the case summary on this one, so thanks for him providing such an erudite summary. You can find that on our website. The second thing before I launch into this one is to say congratulations to any of you that are still watching. It certainly shows some stamina to make through about 35 minutes of Stephen and I droning on. But you'll be pleased to hear that this one is quite a short and swift one. So basically, the facts are that the claimant in this case was a senior employee, and in a nutshell, her relationship with her manager, a Miss Taggart, over a period of time deteriorated. Ultimately, Miss Taggart felt there was an irrecoverable breakdown of trust between her and the claimant, and there were no alternative roles for the claimant within the respondent. So, at a pre-arranged annual appraisal meeting in April 2017, the claimant was simply dismissed. Now, the respondent did have both disciplinary and performance management procedures, but no procedure was followed at all with the claimant. She wasn't even offered a right of appeal.
So, no right of appeal, and no procedure followed. I thought this is isn't this first year law stuff? If you don't go through a process and a fair procedure, I thought that was an unfair dismissal. Might have bearing on Polkey, but what I'm saying, Polkey is of course the case where it all comes from, isn't it? We all know that you can't, by definition, have a fair dismissal. You haven't followed a fair procedure. So, how did she end up losing in this case?
Well, you would think so, wouldn't you? The respondent's case was that following those processes, given the reason for dismissal, namely a complete breakdown in trust and confidence, would have been pointless. It is perhaps notable that in this case, the claimant herself did not dispute that there had been a breakdown in trust. So, going through the Section 98 test, first and foremost, there was no issue as to the dismissal being for a potentially fair reason, namely SOSR. In respect to the Section 98(4) question, the ET held that the dismissal was fair in all the circumstances, in essence because following a procedure would not have served any useful purpose. And to quote the ET, they said, if anything, it would have worsened the situation. As you and I expected, Stephen, the claimant appealed to the EAT, but the EAT did uphold the tribunal's decision. The EAT found that the tribunal had directed itself correctly and held that it is well established that there are rare cases in which procedures may be dispensed with because they are reasonably considered by the employer to be futile in the circumstances. Such a situation is contemplated by Polke. However, the EAT itself was careful to emphasise that this case was, in essence, the exception rather than the rule. And the key point of the judgment is at paragraph 43, if those of you want to look at the judgment, where the EAT stated, the fact that no procedure is followed prior to dismissal would in many cases give rise to the conclusion that the dismissal was outside the band of reasonable responses and unfair. Such procedures, including giving the employee an opportunity to make representations before dismissal and to appeal against any dismissal, are fundamental to notions of natural justice and fairness. And it would be an unusual and rare case where an employer would be acting within the band of reasonable responses in dispensing with such procedures altogether.
So what do you think this case means then? I mean, obviously there's a lot of mention of rare cases where you can avoid following a procedure and it's still not going to be unfair. What do you think about this? I mean, what's your view, Simon?
Well, I certainly don't think respondent employers should be taking a Panglossian view or jumping for joy all processes just yet.
That must be.
This case is certainly the exception rather than the rule. And failure to follow the proper processes is basically asking for trouble, in my view, and will, in virtually all cases, result in a finding that a dismissal is procedurally unfair. You may, as you pointed out, Stephen, get a Polke reduction in terms of the compensatory award, but by following no processes, in my view, you're just asking for trouble.
Yeah, and also, sorry to interrupt you, but don't forget, Polke reduction doesn't apply to the basic award. So if you've got a long-standing employee who you haven't followed a fair procedure with, you're going to end up with a very large basic award that you've got to pay to them. I mean, there's that to remember too. Yeah. Of
course, and the Polke reduction may not be a full reduction. It may be only, at best, a Gunton award as to how long it would have taken to follow a fair procedure. So so you're not going to necessarily, as you rightly point out, extinguish an award either on the compensatory or the basic front. Also, we need to take note, in the previous case of Kelly I mentioned, tribunals are directed to be alive to the mantra of breakdown in trust and confidence as being a cloak for other reasons for dismissal. I think that was actually specifically referenced in Kelly, although I didn't mention it at the time. But it's been mentioned in a number of other cases. That said, where there is genuinely a complete breakdown in trust and confidence, that can be proven, as in this case where it was readily accepted by the claimant herself, then provided it can be further be shown that following a process would obviously be completely pointless and futile, then and only then an employer might just avoid a finding that a dismissal devoid of any procedure was nonetheless fair in all the circumstances. However, with all that said, to be honest, if I was an employer, I'm not sure I would ever want to take the gamble of not following any dismissal procedure at all, though. Would you?
Well, I wouldn't. And also, like you say, trust and confidence, the number of times you see that pleaded as an alternative to a conduct case or even a capability case sometimes, it's frequently relied on. Like you say, I think in this case, there was tangible evidence to show, and the claimant accepted herself, there was a breakdown. But even in a breakdown situation, you're still going to have to be fairly confident that following some sort of process would have exacerbated rather than enabled the claimant to have their say. It's not at all clear about, from the judgment that we've got, why they were satisfied, or the employer was so certain that it was going to exacerbate the situation all the more. I'm sure possibly when you look at the evidence, there's an answer to that. But I think practitioners and employers will have to be pretty... So many employers will say, well, if I have to go through this process, it's just going to make things 10 times worse. That's a common concern for employers, when the reality is that if you don't go through the process, the chances are, yeah, it will make things 10 times worse in another sense, because you'll end up finding that you've not followed a fair procedure, simple as that. So it's not really... Has it changed much, do you think, Simon? I'm not sure it has it?
I don't think it has, and obviously, again, it's a risk, isn't it, to argue that going through the process would be futile I mean, you're basically saying that the decision is predetermined.
Yeah.
So you're potentially making a rod for your own back. And unless you've got very, very clear evidence that it is a completely futile process, then suggesting that it would have been futile is essentially admitting that it's predetermined. So you're potentially stitching yourself up. So you need to be very careful with this. And as I say, I wouldn't be advising any client, except in the extremely clearest of cases. And even then, I'd be very reticent to. So I don't think it probably changes things much. And I think that respondents need to be wary of this one, and those advising respondents need to be wary of this one. So yes. Anyway, Stephen, I did the introduction. So are there any closing remarks you'd like to make to our viewers who have patiently watched us for the last 40 minutes or so?
Absolutely, there is one. If we get good at this, Simon, I'm planning on retiring from the bar. We'll be on Strictly Come Dancing in a few years' time. I think, isn't that what happens? You know, you suddenly find fame on the web, and we're off. We'll be we're doing something quite different. But no, I think hopefully it's been useful. We're trying to focus on the practical stuff, on the things that solicitors are going to find beneficial, rather than just reciting, you know, what a case is all about, and we want to actually get into the heart of it and see if we can offer our views and suggestions. So hopefully these webinars are going to be useful to people. We're going to keep doing it until we're told otherwise. So hopefully there's some benefit to somebody out there. Thanks very much, Simon. Good to see you.
Nice to see you, Stephen, and thanks for watching.
See one another in person soon, hopefully. Fingers crossed. Who knows?
Yes, quite. Okay.
All right.